Hey fellas, so today we're going to be looking at the general differences in torts one can use in order to evade from the liabilities if caused. So there are actually differences and you can take note of those. We will see each of the differences with the relevant case law to make it more understandable. Starting off with voluntary non-fit injury, you can see this. Voluntary non-fit injury. This maxim basically means that if you yourself had given your consent for the future commitments without even knowing the risk involved in such act, then you cannot sue others for the damage caused by them. For instance, let's take a situation where you are about to watch a cricket match and you went for the stadium authorities to buy a ticket, and you bought the ticket and you went for the match, and while watching the match you had been hit by the ball, and unfortunately you cannot sue the batsman for or the stadium authorities for the damage because you yourself given the consent for those. And we will look more similar kind of case law now. Hall versus Brooklands Auto Racing Club. Hall, the plaintiff; Brooklands Auto Racing Club, the defendant. Plaintiff was a spectator, that means Hall, at motor car race, like I just explained now. Let's suppose we will imagine it as a cricket stadium, for instance. So during the race, there was a collision between two cars in which one of the car was thrown out to the spectators' stadium, and thereby causing some injuries to the plaintiff. And it was held that the plaintiff impliedly took the risk of attending such being a spectator in such matches, and therefore he cannot be claiming for compensation in such acts. And the ratio decidendi of this case is that since the plaintiff gave his own consent concurring to the commitments of such conduct, he cannot sue the defendant for any injuries or losses. Therefore, the defendant was thus not held liable. Right. So the second one is based on the principle ex turpi causa non oritur actio, which means that from an immoral cause no action arises. When this is actually a ridiculous defense. When the plaintiff himself has some faults in his own and he is suing you for the damage he had been suffered, you can use this defense, though not that effective. You can use it a preventive measure from avoiding the liabilities, or at least reducing the liabilities. So this principle actually doesn't mean that the plaintiff has own all the complete fault on his own. Let's suppose an intruder or a trespasser comes into your house, and you didn't even know who he is, and you take a gun and shoot him. He's dead. And let's suppose his wife is claiming for the compensation. Dude, you don't have to shoot a guy who's just trespassing into your land. So even you have mistake on your own for giving an extraordinary and unreasonable force in order to prevent a greater mishap. And he had some fault too for trespassing without even any consultation. So it's both of your party fault, and you can take this principle as just a measurement in order to show that the plaintiff also got involved in such conduct of committing a mistake. So, and we'll look at a case law in which both the plaintiff and Holbrook, the same example I just showed today. So the defendant's land was a garden, and the plaintiff was a guy who was trespassing into it and was injured by a spring gun set by the defendant without any notice in the garden. So what can be the judgment? Judgment is that even I don't know, it doesn't even mention in the book. So let's suppose the judgment is that no one's liable. It's just the spring and cannot obviously kill him. And we have actually two bases. The one is that the criminal or the defendant who is claiming for the compensation suing the plaintiff for the wrongful act he has committed, but if he has a fault, you do have a fault. But on the other case, or the other basis, unless some unlawful act conduct on his own part is connected with the harm suffered by him as a part of the same transaction. Like let's suppose lorry, you are a bridge contractor, renewing a old bridge, and the lorry carrying a heavy load weight, trying to pass through the bridge you are reconstructing, and you have warned him not to go with the overload, even though he went through the bridge and caused some damage. You wouldn't be liable because he chose to do so. So the third one is the inevitable accident. Actually, most of the cases comes under this defense because it's so silly. Yep, it's silly. Like, you can even consider the case inevitable accident. You can even imagine what's accident. It's an unpredictable event which occurs without any reasonable precautions taken or without being anticipated by someone. So let's take a case law in which the plaintiffs and defendants' dogs were fighting. Yes, fighting, and when the defendant trying to separate them, accidentally hit the plaintiff's eyes. Actually, this is a famous case. Yep, really famous case. Who was standing nearby. The injury to the plaintiff was held to be the result of pure accident. Therefore, no liability. Yep, that's it. Free case. And so, looking into another two cases, we have one case, Stanley versus Powell. So in this case, the plaintiff was standing in behind the tree, and the defendant who was doing the shooting practice, the rich used to do, and accidentally the bullet penetrated through the tree and hit the defendant in the plaintiff, causing a severe injury in the back of him. So he's claiming for the compensation, and obviously it can be held that it's not the plaintiff's or defendant's fault. It's inevitable accident. So throwing our lights onto the next case, we have S. Vedantacharya versus Highway Department of South Africa. This was basically a bus accident case, and the plaintiff's relation have been killed or died in this accident. It was held that there was a breach in lake leading to the huge water be filled in the highways, due to which the bus collapsed and crashed. And interestingly, in this case, we have the high courts doing the other method for the judgment. Instead of putting it as an inevitable accident, like there was a heavy rainfall and the bus met with the accident, and the highways department cannot do anything with it. But here the court held that such circumference can be anticipated, and such circumference can be precautiously dealt with it to avoid such situations. So it was held that High Coast Department of South Africa was actually liable. Since such circumference, you have to be ready for that, and especially during the winter season. and thus making it liable. So, in this case, we come to know that not only inevitable accident, but when the circumstances are predictable or like precautiously anticipated, we cannot claim this rule of inevitable accident. The fourth one being the act of God, like it's known to everyone, I suppose. Like it's the act of any natural forces, the disastrous forces, the tsunamis, the earthquakes, and such circumference which could not have been foreseen or which could not have been guarded against or as an accident due to the natural cause without any human intervention. And there are two essentials working of natural forces, their occurrence must have been extraordinary. We have a case law on this. So the wall of a collapsed building fell over the children of the respondent, and thus he went through the goal for the appeal. And the Madhya Pradesh High Court held that the defendant could not take the defensive act of God in this situation, as much rainfall during rainy season was something not that extraordinary and can be guarded against. Like we have seen in the previous case too, this can be anticipated and could have been taken the previous necessary precautions in order to avoid it. And in this too, we have the predictability of the future repercussions of such extra like natural forces. So there are four more defenses: the private defenses, a mistake, necessity, and statutory authority. And I will be speaking it in the next video. Cheers.